Welcome to Lowndes Legal Talk, where we share perspectives on legal and business issues affecting you.
Hi, everyone. My name's Jackie Bozzuto. I'm a partner here at Lowndes, and we're here today to talk to you about property tax decisions that have recently come out. I practice in commercial real estate, and I've been practicing in that area for 30 years. When I have questions or my clients have issues with property tax assessments or appeals, we turn to Brendan and his team because they are experts in this field. And so Brendan and I are here today to inform you about a recent decision that came out of the appellate courts in connection with Florida real property taxes, and to give you a heads up about what that may look like going forward. The Disney Yacht and Beach Club appealed their 2015 tax assessment that the Orange County property appraiser assessed on their property. That went to trial and then went up to the appellate court, and the appeals court just came down with that decision. So Brendan and I are here today to tell you a little bit about that. So Brendan, can you share with everybody a little bit of the background of how we got there and what the background of that case was?
Sure, yeah, and I think you gave a great starting synopsis for it, Jackie. So great to talk to you about it. That 2015 assessment on the Disney Yacht and Beach Club is the very specific valuation we're talking about. But big picture, the Orange County property appraiser in 2015 really determined that a severe increase was due to almost all hotels and a lot of hospitality commercial properties. So all the hotels in 2015 in Orange County saw a rather significant uptick in their valuation, which resulted in a number of lawsuits being filed, including all the Disney hotels, all the Universal hotels, Four Seasons, you name the hotel, particularly resort style, there was an appeal. The first one to go to trial, and thus far the only one to go to trial, was this Disney Yacht and Beach Club case, just on the 2015 assessment. So as you said, the trial court heard a multi-day trial, lots of experts, lots of witnesses, a bench trial, and came down on the side of Disney with a very significant reduction in its 2015 valuation, which would result in significant tax relief. The property appraiser appealed that decision, and just recently the appellate court, the Fifth District Court of Appeal, came down with a decision that was kind of a mixed bag and effectively said that Disney's argument regarding what we deem ancillary income was correct, that it was too high on a property appraiser's side, but it wasn't done correctly still. But more importantly, the appellate court said a method of value called the Rushmore method that was used by the Orange County property appraiser was unconstitutional and shouldn't be allowed in the state of Florida. So that was the big seismic news from a property tax perspective, because that hadn't been determined before in Florida, had been determined in some other courts around the country, with some courts approving the Rushmore method and some courts not approving the Rushmore method. But this was the first time it had been heard in Florida. And that decision came out in June of 2020 and was ultimately appealed. And we'll talk about that in a second too. But that's the background of how we got here today.
And so what is the status of the case now?
Yeah, so rather immediately, there's always short time frames for appeal. The Orange County property appraiser appealed the decision of the Fifth DCA, that District Court of Appeal. But they only appealed one very specific issue. They asked for a rehearing on the determination that the Rushmore method, which is a method of valuation largely used for hotels, it was inappropriate and was unconstitutional and shouldn't be allowed. They didn't challenge the other determinations made in the appellate court decision regarding the value or regarding how to handle an income approach, and specifically how to deal with ancillary income, which is that income that's not specifically related to room rentals. But they challenged that Rushmore and asked for a rehearing on that. And lo and behold, a pretty quick turnaround. The Fifth DCA just recently, just a week ago, in early August, said, okay, we're going to reevaluate that, and we have issued a new decision that takes out the line or lines that say Rushmore isn't appropriate. So they did a 180 on the Rushmore determination and said, we didn't like it here. We didn't like it how you interpreted it in relation to the Yacht and Beach Club, but we're certainly not going to say that it's unconstitutional across the board.
Huh. Okay, so what does all that mean for property owners?
Right. So the legal stuff is fun for me to talk about, fun even as a real estate attorney for you to talk about. But where the rubber meets the road is really how this is going to impact commercial property owners, and very specifically those in the hospitality industry in Orange County, in Central Florida, within that 5th District Court of Appeal, and statewide as well. And the answer is, for hotels specifically, the Orange County property appraiser is now being required to look at their income analysis in a different way. What they were doing before is they were taking all income that came in at the property. So they were saying, here's the room income, here's the income that comes in from the restaurant, here's the income from the spa, bottom line dollar income. And they were applying all of that towards ultimately determining a net operating income on the property. What the court, both the trial court and the appellate court, decided is you can't do it that way. You have to determine based on what is attributable to the real estate only. So you can say all the room rental, but then you have to say, what would that restaurant in that resort style hotel rent out to if it was rented out to a third party? What's the dollar per square foot? What is that spa worth on a dollar per square foot basis, or that retail space, or that banquet space? You can add that to the NOI, but not the actual income that comes in from the restaurant or from the spa. And that's a big shift. So there's going to be a new calculation that needs to be done for any hotel that has this type of ancillary income: retail, restaurant, spa, banquet. And it should start immediately, but we're going to see how that actually plays out.
Okay, so what would you recommend is the next step for people who are watching this, or people who have these concerns, and to take advantage of that decision that came down?
So because this is all sort of real time, decisions in June, July, trim notices come out in August. So trim notices are coming out right now, and those are your truth and millage notices, which tell commercial property owners and residential property owners your proposed valuation and proposed taxes for that 2020 year. Mm-hmm. It just is happening now. So there's been no time for a change of analysis on the Orange County property appraiser's part, or any other property appraiser's part that may be doing the same thing around the 5th DCA's circuit or around the state. So what I say to hotel owners now in particular, or anybody that sees ancillary income as attributable to their property, look at that valuation closely and probably file an appeal this year, because you want to make sure that when changes are made, that you have an active appeal, so you're in the game effectively. So if you don't have an active appeal, there are no changes that can be made. If you miss that deadline for appeals, of which there are 2, either administratively or filing a case in circuit court, you're out, even if there are changes made after the fact.
Okay. When is there a time frame that's specific for people, so that they kind of know once they get that notice what their time frame is for filing?
So the deadline for filing the administrative appeal, which is the easier, less expensive, less onerous than filing a suit, is 25 days from that trim notice. It's usually stated right on the trim notice. So those deadlines usually fall in early September, and they are strict deadlines. So I would recommend, again, looking closely, checking out that filing deadline, and likely filing that VAB petition, that Value Adjustment Board petition, just to make sure your rights are being protected and you have time to more fully analyze how your property should be valued.
Great. Well, thank you, Brendan. I hope that was helpful for those of you who are watching this. And if you have questions, of course, Brendan and his team are always here to help.
Thank you for joining us for Lowndes Legal Talk. For more information about today's topic, or to learn more about our attorneys and practices, please visit lowndes-law.com.